Good morning or afternoon to everyone. My name is Kevin VandenBroeke, and today I want to walk through what estate planning looks like in 2026 after the recent tax law changes in the One Big Beautiful Bill Act. My goal is to make this practical. I want to help you spot where older plans may no longer fit the law, your assets, or your family goals, and where a review may be worthwhile. On that note, a brief disclaimer before we dive in. I do want to emphasize that today's presentation is for general educational purposes only. It is not legal, tax, or accounting advice for your specific facts. Estate planning is highly individualized, so I encourage you to use tonight or today as a framework for better questions and a better review. Transparency matters because good planning starts with good facts. A good outcome depends on understanding your documents, your assets, your family dynamics, and the tax issues that apply to you. So today's goal is not one size fits all answers, but a useful framework for spotting issues. Just a quick note, you can enter questions into the Q&A in the webinar, as well as into the chat. As we go through the presentation, I will do my best to answer questions as they come up, but I will make sure to hit all that I can at the end of the presentation. And anything that we can't really answer today during the webinar, I will make sure that either myself or one of our attorneys here can follow up with you as your needs may vary. So here at Kopenbarger, estate planning is very much a team effort. Good planning often involves coordination between estate planning, tax, administration, business planning, and sometimes even our litigation support. That matters because many estate planning problems come from a lack of coordination, not the lack of documents. So here at Kopenbarger, we have a team of 12 plus attorneys, plus our support staff, really sitting back ready to help serve each and every one of you. The same is true on the staff side. A well-run planning depends on implementation, organization, and follow-through. Many problems happen not because planning was never done, but because it was never fully carried out or maintained. And here at Kopenbarger, our staff of paralegals, office assistants, administrative assistants, anybody here is really just poised to help, kind of finalize that project for you, along with your attorney staff. We have locations throughout California. We work with families in a wide range of situations, from straightforward plans to real estate heavy estates, business owner planning, blended families, and multi-generational structures. Many of the issues we'll discuss today show up across all these settings. So we have offices throughout California, strategically spaced to hopefully be able to help each and every one of you. And then for those of you that might be outside of the state, we are definitely happy to schedule Zoom appointments, calls, all of those fun things. So today we're going to cover 5 areas. We're going to talk about plan health checks, exemption mechanics, coordination, real estate risks, and legacy planning. The goal today is to keep this practical so you can identify what to review and why it matters. We're going to start with the foundation. Before talking about any sort of advanced planning or tax strategy, we really need to know whether the core documents and systems are actually in place and functioning properly. So we're going to talk about plan health checks and taking an inventory. The first question is always simple. What do you actually have? Do you have a trust, a will, powers of attorney, healthcare directives, entity documents, deeds, insurance paperwork? How about your current beneficiary designations? Do you know where all of your originals are and when they were last reviewed? You don't need perfection, but you do need enough clarity to know what exists, what is missing, and what may be outdated. So before any meeting, when we're sitting down to talk about your estate planning in light of recent legislation changes, really, what you want to sit down and do is list out all of your estate documents, when you first drafted it, when you updated it, how many times have your will changed? Did you keep the old wills or were they destroyed? For your assets, you definitely want to gather your balance sheet inputs. A big part of our planning is not only knowing what assets you have, but how much they're valued, because as we'll learn a bit later and we'll discuss, the amount of money that you can pass to your heirs tax-free, it matters. We also ask that you locate your originals and your records, and then you make sure you note the last time you sat down with an attorney. You'll probably hear this from me several times today, but generally, if you're not meeting with your estate planning counsel at least every 5 years or so, just for a quick check-in, your plan's probably out of date and you probably need some updates, or at least some things have probably changed. We're also going to try to identify implementation gaps in your planning because a trust only works if it's well funded. A beneficiary plan only works if the designations are current. Entity planning so that your businesses go to the people you want and the people that are best suited for it, that only works if ownership records are going to match reality. So one of the most important review points is implementation. Are the assets actually aligned with the plan? And have you clearly distinguished between incapacity planning and death planning because those two are different. With incapacity planning, these are people that are going to be running things for you, running the show, so to speak. If you can't, you're still alive, but you can't make decisions for yourself. So not only are you still relying on your assets, your family likely is as well. Whereas when you pass away, it goes to the next generation or to your beneficiaries, and you may not have as much thought over who controls your assets at that point because the beneficiaries take the control. So really kind of defining who's in charge and when, very important to make sure that, when your plan is needed, it works the way you want it to. Next, we want to think about who is actually supposed to act when something happens. Who's the successor trustee, the financial agent, the healthcare decision maker, and the backup? The right names on paper matter, but so does whether those people are available, organized, and well suited for the role. Oftentimes, when we're talking about planning, everyone just assumes, oh, well, all of my kids should be co-trustees because, they're all receiving equally and we don't want anybody to feel left out. I generally advise against co-trustees, especially, if your children are your trustees, just because you get a lot of cooks in the kitchen. And usually being a successor trustee to a parent's trust, it's not so much a privilege as it is a burden to make sure that everything is done right, all the I's are dotted, T's are crossed, and everybody ends up with the assets the way, parents wanted them. So really having these conversations, making sure the people that are going to step into these decision maker roles are well suited for the job and understand what they're going to need to do when that time comes. You always want to make sure you have your alternates lined up. You want to make sure the rules are clearly spelled out. So that way your assets, the legacy that you created is being managed the way you want it to. Conflict prevention is always a large goal when it comes to estate planning. Families often run into fiction over unequal treatment, blended family issues, sentimental assets. Businesses are a large one. Vacation properties create more fights than you would imagine. And the biggest thing is unclear expectations. Everybody has an expectation of what they may or may not inherit, and that could be completely different from what your actual plans are. So a real good review should identify conflict-prone areas before a crisis, not after. While we do love our litigation team here at Cope it is always our goal to make sure that our clients, when through their planning, don't have to end up over there fighting over anything once they pass away. So we do want to prevent litigation whenever possible, and a clear, concise plan can help do so. And a big important part of that is covering the different friction risks that exist within a plan. Um, Unequal beneficiaries plans, that's always one that comes up, especially in the role of blended families. So if you have kids from one marriage, from both spouses in this case, usually dividing things up equally. It really depends on how long they've been married, how the family works, but everyone knows their own family best. We can only really advise you on what we've seen, and then kind of talk you through potential pitfalls. But having those types of kind of awkward conversations about what might happen, what strife might be in the family, really helps identify things that we can clear up and plan ahead for. That way, the entire administration process becomes easier on your beneficiaries and heirs. We do like to create a one-page family snapshot kind of as well, just kind of show who's who in the family, who's kind of set to receive what, and that really it spells it out a bit easier for you as well. So now we're going to move into the tax law portion a bit. In 2026, the main conversation is no longer just waiting for a sunset date. So before the One Big Beautiful Bill Act passed, the Tax Cuts and Jobs Act passed in 2017 had raised the federal unified gift and estate tax exemption up to 10 million index for inflation. So at the end of last year, it was at 13,990,000 that could pass tax-free from one taxpayer to their beneficiaries. Spouses give unlimited amounts to each other, and there's some other rules there. But essentially, it was just shy of $14 million, through the end of 2025. Without the One Big Beautiful Bill Act passing, that was scheduled to sunset back to the $5 million index for inflation. So effectively cutting it in half. So a lot of the big planning you saw end of 2024 and the beginning of 2025 was people planning for this eventual sunset and making sure they could use as much of that exemption as possible before it came back down. Then a new tax law bill came through, and they ended up moving that exemption all the way to $15 million and index for inflation starting next year. So 15 million this year for 2026, and then it'll start going up slowly year after year, with the annual gift exclusion being $19,000 going up as well. We'll cover exemptions a bit more into the mechanics as we go through this, but that's kind of what happened. So there's a big push for planning right before this bill passed, and then after the bill passed, instead of sunsetting, they locked it in, and the new bill does not have a sunset clause to it. So unless Congress comes together and passes, more sweeping tax reform, which could always happen, the exemption is going to stay at that 15 million and go up unless Congress does act on that. So the better question now is whether old documents and assumptions still behave the way the family wants under the current law. So with exemption mechanics, there's a big reliance on the different rules. We want to identify exemption-based strategies, which include portability assumptions, GST exposure, formula-driven documents, and whether your plan is focused only on estate tax when basis planning may matter too. This is especially important when older plans were built around very different exemption assumptions. So the unified estate and gift tax credit has been variable over time. So prior to the Tax Cuts and Jobs Act in 2017, it had moved up in 2012 to $5 million index for inflation, then 2017 the 10, and now to the 15. Prior to 2012, the exemption usually hovered around $1 million, which only meant $1 million could pass to the next generation from a taxpayer before the estate tax kicked in. So a lot of plans that are now 15 or so years old, they planned for that, where it was really focused on really minimizing the estate tax, and the income tax parts of the plan weren't really as beneficial as possible. Now, with such a high unified credit and estate tax exemption, we are going to go ahead. I'm sorry. So now with the unified estate tax exemption being so high, we no longer have to really plan for the estate tax if your overall net worth is under 15 million or 30 million for a married couple. But we do want to plan for the income tax exposure your beneficiaries may face, and that's what's called basis planning. So if we, instead of moving assets outside of your estate, leave it in your trust, leave it in a basic trust in your estate, so it's subject to tax, even though there is no taxes under that amount, your beneficiaries get what's called an income tax basis step up on your passing, meaning they can sell the assets at, upon your death without realizing any capital gain. So we can really plan for income taxes for your beneficiaries if done right. So what we do when we're going through your documents is we try to flag the different formula clause driven documents. Generally, for those of you that are Cope & Barker clients and you have some of our different trusts, you may have a JPAT trust, which is just a joint probate avoidant trust. You may have what we call an AB trust or an ABC trust. It's those AB and those ABC trusts that use these formula clauses to make sure that you're not subject to the estate tax. Generally, our documents are drafted to plan for changes in the unified credit, but if you're coming from a different law firm or an older practitioner, they may have actually used dollar amounts there. And with that unified credit changing so often, you definitely want to make sure that any formula clause driven documents are updated to make sure you're using as much of that credit as you can. You also want to separate estate tax planning goals from your basis planning goals. So really knowing what your asset makeup is, what your beneficiary plans are, who's set to receive what, and kind of what the overall financial state of your estate looks like is beneficial, because we can help plan better for your legacy and for your beneficiaries. So when we're talking about clause behavior, this is one of the most important technical review points for at least for us attorneys when we're sitting down looking at your documents, helping you determine what needs to be updated. Older wills and trusts often use formula bequests tied to the exemption amount. Under current law, those formulas can sometimes overfund what's called the bypass style trust, or push more assets into tax-driven structures than the family actually intended. So the real question becomes whether those clauses still match what your goals are. We want to make sure the bypass funding is still matching. We want to, see if you have what's called a Q-tip trust, if there's disclaimers or portability-based alternatives that are better suited for this type of environment instead of those formula clauses. We definitely want to revisit trust terms for possible second step-up planning if you are in a community property state. So lots of different, unfortunately, it's a lot of the legalese in the trust that at this point kind of need to be reviewed and updated. So when we're talking about exposure, we're talking about identifying our family, our clients' actual tax problems or tax exposure. For some, federal estate tax is still the issue. So if you have that $15 million or, if you're a married couple with $30 million in assets, or if you're just slightly under it, but you're, still in those earning years or your assets are going to appreciate, especially real estate here in the state of California, chances are you might kick over into those higher limits. Beyond that, just like people were planning for a sunset before the end of 2025, a $15 million unified credit is the highest it's ever been. Who knows with, the drastic changes that have happened across our Congress and kind of the political spectrum here in the United States the last 20 years, what the next 20 years are going to look like. So it seems like taxes are generally on the table. And the last two major tax bills that have been passed touched upon the estate and gift tax when generally, they focus on the income side. So it's always possible for that exemption amount to come back down lower. And then when we're talking about that, we have to, realize it's a use it or lose it type exemption where we can use up to that full $15 million now. And if they lower it, well, we've used it up. So they can't claw back what you've already used. So really identifying where the best strategy is for you, we need to look at, whether the assets are exposed to estate tax, which ones we do want exposed to estate tax so we get a step up. When a tax burden is going to have to be paid upon your debt, we want to make sure there's liquidity for it. We definitely want to compare estate tax strategies against lost basis step up opportunities. Really, sitting here, it's not a one size fits all approach. We really have to kind of get down, and that's why it's such a coordinated effort between your attorneys, your CPAs, your financial advisors, and your business owners and operators. We really need to make sure that everything is working the way that it needs to. The right time to review your plan is usually when something changes, whether there's been like major appreciation in the value of your assets, if there's a pending business sale, unfortunately, upon the first person to die with a married couple, or if you're going to start gifting out some assets to your loved ones before you pass away. Or if you've moved, like let's say you've left California, it's a great time to sit down and talk to your attorney to figure out whether your California-based trust still meets your needs or whether we need to get you in touch with local counsel. These are the events that often reveal whether a plan is still aligned with the current law and the family's real needs. So this is usually when we do see our clients is, when these types of, triggers are occurring. But like I said, if you have not looked at or updated your plan 5 to 10 years or so, there's been a lot of changes to not only the tax law, but just kind of the overall trust and the trust law here in California, where it's probably time for at least a review, if not an update. So once we understand the documents and the tax framework, the next question is whether the plan is coordinated and flexible enough to adapt over time. So a good estate plan now usually requires coordination between the attorney, CPA, financial advisor, business counsel. Planning's no longer just about the estate tax. It may also involve basis, charitable planning, entity structures, retirement assets. And then for those of you in California, there's a whole litany of California specific issues. Good results are going to usually require clearly assigned lanes. So knowing which one of your trusted advisors has what role, very important. Making sure they're on the same page, extremely important. I would say I spend more time on the phone with my clients' advisors than I do with my clients sometimes, just to make sure we're all on the same page. Really important as we move further and further into the 21st century in the digital era. Centralized document access saves so much time and so many headaches for your advisors. Making sure everybody has current documents located in the same place that everyone has access to. It's a godsend a lot of times, and quite frankly, I love it. So if you have that opportunity, definitely take it. That way you make sure all your advisors are on the same page and there are no issues at all with getting your plans going. So the execution process, this is more about the process discipline. Complex families often benefit from a simple annual review meeting to review the asset list, note family or business changings, confirm, whatever roles may be changing, and identify major upcoming transactions. Most plans don't fail suddenly; they drift and fail over time. Generally, for our advanced planning clients, so those that I set up, the more advanced trust for, or if we have clients that own and operate businesses, we try to meet with them at least annually to sit down for about an hour or so just to make sure that everything's going to plan. A lot of times the attorney is the last person you forget to call when you have a new grandchild, or if one of your kids has left your business and gone off to start their own. So talking to your attorneys kind of about what's going on at least annually or so just lets us kind of identify where changes may be needed. And we can definitely update any documents we need, or at least our notes, so that if something were to happen, we would know kind of what you want in that moment. Meeting summaries very important for that as well. If you're doing a whole family meeting, which I love family meetings, just sit down, have some summaries so everybody knows what was reviewed. That way, if there is a sudden event which you are no longer necessarily in the driver's seat, at least your family isn't completely in the dark at that time. A major theme in modern planning is that flexibility beats prediction. The last few years, just the changes in the tax law from 2017 to now, is basic proof of that. No one knows exactly what future law or family circumstances are going to look like. So now a lot of practitioners are defining good plans as those that emphasize tools that allow post-death or future adjustment rather than rigid tax formulas that lock families into one path. Like we talked about earlier, these are things like disclaimer and Q-tip flexibility in the trust, powers of appointment for post-mortem adjustment. So if you wanted to move assets from one class of beneficiaries to another, preserving substitution powers for basis management, and then drafting for remarriage, blended families, and asset protection realities. It unfortunately today, as we know, the majority of marriages unfortunately end in divorce. So making sure that your kids, your grandkids, great grandkids, making sure that your legacy and your assets stay with your family, definitely important. And having that kind of flexibility and those types of safeguards built into your trust really help as well. A successor trustee should not have to become a detective. Good planning is going to include a master asset list, clear annual tasks, consistent naming conventions, and a successor-ready binder or file system. Administrative clarity makes the plan easier to carry out and reduce mistakes. Really, you want to set the next generation up for success, especially the person you are putting in the role of your successor trustee. Um, Luckily, most of our clients, when they come to us for a trust administration, we are generally the attorneys that also drafted the plans. A lot of times we aren't, but most of the times we are. But when we are, we at least know where most of your assets, where your documents and those things are. When you're coming to us, when you weren't one of our estate planning clients, but you might need trust administration, one of the biggest tasks is generally trying to help our clients identify the different documents that may exist, identify the assets, and track them all down. So having everything just kind of lined up and spelled out in one place is going to save your loved ones and your trustee a tremendous amount of work and quite a big headache. For California families in particular, just because we are a California law firm, I'm a California attorney, I just want to talk about real estate risks. They exist across the United States, but California is particularly heavy with them. Real estate deserves its entire own section or entire presentation, but we're going to go through it today a little bit quickly. Real estate planning is not just about who gets the property, but also about the title, the entity structure, reassessment risk, and whether multi-state ownership creates added tax or administrative issues. So generally, with ownership mapping, you're going to start by listing every property and how it's owned. If it's owned personally, is it titled to your trust? Is it in an LLC? Is this property one that's owned by many different families and you just have sort of a general partnership set up taking care of a rental property? Is the property across straight lines? If the family assumes a transfer to children or through a trust will avoid reassessment, that assumption should be reviewed carefully under current California law before anything actually is transferred. So Prop 19 a few years ago really changed the reassessment landscape upon inherited real estate. So really now mapping out, not only who owns the properties currently, but who plans to kind of inherit them. Making sure that if the property does get reassessed, if reassessment can't be, avoided, or if reassessment can't be prolonged, is the beneficiary who stands to take over this real estate, can they afford the new property taxes on those? You want to note any debts or guarantees on the property. Really just have a clear line of ownership, and any type of, you know, um, burdens on the property themselves kind of listed out. That way we know, how to best help you and help your beneficiaries. Entity planning can be very useful for liability control and administration of your real estate assets, but it does not create blanket exemption from California reassessment rules. Whenever real estate is held in or moving through entities, those transfers need to be reviewed carefully before they happen. So generally, reassessment occurs on real property here in California, either when if it's owned by individuals, when that ownership basically changes any amount, with a entity owning the property, you generally look at change of control of the entity. So let's say you own a rental property, you put it into an LLC, and you start gifting portions of that LLC to your children over time. So that way, during your lifetime, they can still start receiving some of the income from it or some of the control from it. Generally, you're not going to be reassessed on an LLC ownership transfer like that up until the point where I believe it's 33% of the entity itself has changed, or a majority of the entity has changed, depending on how the interest breaks down. And then that portion that has changed will be reassessed. So just because you put it into an LLC doesn't mean that it's not going to be reassessed. It just kind of lets you plan that a bit better, which is why really going through what your counsel and really kind of help having your attorneys help you with this planning, it's going to save a ton in reassessment in the future, and really make sure that your plan is working the way you want it to. You also want to make sure ND records are kept updated. So any operating agreements, any changes to like shareholder structures, any of those things really are done the way they want. Buy sell alignment to make sure that, if you pass away, the right beneficiary is going to end up with the right entities, to make sure that, all this change in entity planning is done right to really kind of prolong this reassessment. So we have a question. Back in the normal California days, the son daughter of a property owner could take on the property under the same Prop 19 status of their parents. What has changed? So under Prop 19, the new rules effectively are for a to avoid reassessment, the property has to be the primary residence of the original owners, and then it needs to go to their direct descendants, so their children. And then the children need to use that as well as their primary residence. So the exclusion from reassessment really only applies to primary residences now. And generally, there has to be a couple of years of ownership on both sides, both parents and kids, to avoid that. And then also that exemption is now only up to $1 million in value, which here in California, especially here in Orange County, where our South Coast Metro office is located, it's very easy to get properties over $1 million. So generally, even though if your property is worth $1.4 million, you'll get a $1 million exemption from reassessment, but the other 400,000 is still going to be subject on a pro rata basis to that reassessment. So it changed that a lot over the last, I want to say 5 or 6 years, that we've kind of been in this new regime. So income concentration. So high tax exposure and after tax efficiency is generally a big planning concern for a lot of our clients. There's rental income, there's business income, there's state and local tax deduction planning, there's pass-through entity tax elections, and it all needs to be coordinated. The structure should produce a real world benefit, not just complexity for complexity's sake. Um, I like to use myself and my family as examples whenever I can. My dad is one of those people that likes complexity for complexity's sake. So he has several holding companies that own. He's a restaurateur. He has several holding companies that own those and some other properties and those things. And when I sit down and look at his plan, I understand it because I kind of helped him come up with it, even though he's gone on his own a bit there. But really, kind of understanding how your entity structures work and how they best plan for you is extremely important. A lot of times clients come to us where their planning wasn't done with Copenbarger, and they'll come with several different entities, you know, a whole slew of trusts and say, this is too complicated. I can't make my plan work. And a lot of our goal is simplifying that for them. So really, you want to make sure your plan is efficient as possible. And generally, that doesn't more is not always better in this case. We'll say to there. And there's a lot of different competing benefits through different types of plans. So what I will say is if you are considering putting real estate you own into an entity for liability protection or some of these other good benefits like the pass-through entity tax election as a way to deduct more state and local taxes here in California, definitely set an appointment with one of our attorneys, preferably. I can sit there through it. Our attorney, Catherine Grout, she's our business planning attorney. She can help you with that as well. And all of our estate planning attorneys, they know how to kind of help get you through this or at least point you in our direction to get you what you need. Liquidity planning is broader than just the estate tax. Even families that are under the federal exemption may still need liquidity for property expenses, equalization among children, buyouts, administration, or to avoid the forced sale of a highly appreciated asset at the wrong time. What this is referring to is generally, it takes cash to move your estate. There's going to be bills, there's going to be money that needs to go out to your kids, all those things, and you may not have a very cash rich asset holding. You may own a lot of properties, but there's not a lot of actual cash sitting there. So really sitting there and looking at what you may need, or at least what your estate may need upon your passing to make sure the bills get paid without having to sell everything off at an inadvantageous moment, very important and part of our planning concerns when we sit down to talk about that. We're going to shift from the tax and mechanics to purpose. Estate planning is not just about planning for tax and who the assets go to, but it's about values, family communication, and preparing the people who may one day have to carry out your wishes. Let's talk about the foundational questions behind legacy planning and family intent. What is the purpose of the family wealth? What values should it support? How much should heirs know, and when should they know it? If the purpose of the plan is unclear, the people implementing it later are left to guess instead of having those guardrails in place to move them through what they need to. So this is where the family dynamics and technical planning meet. Some beneficiaries need structure, some need flexibility, and some may be ready for outright ownership. It's also a good time to ask whether older tax-only restrictions still make sense for the family today. So you really want to make sure you're matching your distributions to the maturity of your beneficiaries. You want to plan for milestones and emergencies, and you want to choose capable trustees, especially if you're going to be putting assets into a series of trusts if you want to keep things protected long after your passing. And so we're going to set up irrevocable trusts. You want to choose a list of very capable advisors and trustees who are going to be there for long periods of time. And not only the trustees themselves, but give them the power to really train the next generation of trustees after them. If this is a trust that's going to be around for your children and grandchildren, potentially great grandchildren, you'll want to make sure that your decision makers are ready to go and operate on that plan. There's always a charitable integration into legacy planning as well. So charitable planning, it's not just about generosity. It's also about timing, coordination, and choosing the right structure. So if charitable giving is part of the family story, it should be approached intentionally and integrated with the rest of the plan. Charitable planning really has so many benefits to it, not just beyond the good feeling of giving back and doing the right thing. Charitable planning, if you are in the taxable estate side of things, we can set up charitable plans that bring you back below that taxable threshold while still, receiving income from your assets, but making sure the charities that you care about are funded upon your passing. We can make sure that, a some type of family foundation is set up where that legacy of giving and that legacy of just charity in the family continues generation after generation. And we definitely want to document your charitable intent, and you make sure that your successors understand that and they're brought into that spirit of giving, while you're still able there to kind of counsel them on it. And a great plan can still fail if the successors are unprepared. Do your trustees know that they are trustees? Do they know where the documents are and who the advisors are and what the family dynamics may look like? Sometimes the best gift you can give to your successor trustees is a roadmap. You definitely want That's where the family meetings come in. If there's that annual meeting where everybody knows, hey, we're going to sit down and talk about this, that helps. You can really, prepare for contingencies where the family may not be getting along and define what dispute resolution process looks like through your trust. And beyond that, if you know there's going to be problems and if you know your successor trustee may have different needs, you can update your plan regularly while you're still alive to make sure that they are set up for as much success as possible. So the key takeaways, what's changed? The key thing I want you to take away from this webinar is that the message in 2026 is not panic. You may have heard practitioners kind of selling panic in the years prior to this new bill passing because of that sunset, but that's no longer the case. We're locked in at that 15 million for at least the next couple of congressional sessions until something major changes. It's time to review. Older plans may still be good plans, but many older plans need to be retested under the current law and the current family needs. The first major takeaways are these. Older documents may not behave as intended under current exemption levels. Portability and GST planning still need active attention. And basis planning now matters more for families than pure estate tax administration or minimization. Really, you also want to focus on real estate and entity rules that can otherwise undo good planning. And you want to make sure your plans are flexible, not only flexible, but actually in place. The takeaway that I also want you to take is remember, post-it notes in your plan do not work. You can't put a post-it note into your plan and then expect that to kind of be the end all be all. If there need to be updates, you need to sit down with your attorney to make sure that happens. That way you can avoid any fights in the future. So where does this leave us? For some families, the answer is a straightforward health check. For others, especially those with substantial real estate, businesses, blended family issues, or multi-generational planning, the review may be more involved. But the goal should always be the same. Make sure the plan still works the way you think it does. Okay, so how can we help here at Copenbarger? Copenbarger, we can definitely sit down and help you review and establish your plan to make sure it's working for you. We can help you decide how your legacy is being handled. You can help you learn strategies to protect your loved ones and avoid stress, delays, and extra costs. We can get give you clear guidance on the documents and decisions that put you in control. And we can give you the clarity, support, and planning you need to move forward. At this time, if you guys have any questions, please feel free to put it into either the chat or the questions and answers format. And then beyond that, why choose Copenbarger? Because here at Copenbarger, our role is to help families not only establish a plan, but to understand it, maintain it, and adapt it as life changes. That includes the documents, but also the coordination, the tax awareness, and the practical follow-through that good planning requires. We have been around since 1979. We have over 250 years of combined attorney experience. Several of us hold our advanced tax degrees, several certified specialists in probate, estate planning, and trust law. Our support staff, I would have to say, is among the best in the business. And we have our 8 different office locations all throughout California to help serve you. So if you do need our help, please contact us. There are many different ways. If today helped you identify even one area where your plan may be outdated, incomplete, or no longer aligned with your goals, that's a useful result. It means you need to come in and talk to somebody. If you're unsure whether your current documents still work well under the current law, that's exactly the kind of issue worth reviewing with us. So as you can see here, you can call us anytime, visit our website, email us, find us online at all the different social places. And then there is going to be in the chat a survey or a digital evaluation link. Please, if you wouldn't mind filling that out, we would definitely appreciate that. And this webinar does qualify you for a free estate planning consultation with one of our estate planning attorneys to either review or establish your documents for many of the different things we identified here today. So I'm going to leave the chat open for a bit. If there are any questions, please feel free to put that in there. And then also there is going to be a meeting in late April at the Marriott in Sacramento. Let me pull up my calendar. I'll tell you when that is. 1 second. So if you are in the Sacramento area, we are going to have a live presentation coming up. And I'm pulling up that date right now. Then we have another question. Do you keep copies, originals of completed trust packages to ensure the documents are not lost in some way? Yes, we definitely hold on to electronic copies, but generally the originals go with our clients, but we always keep an electronic version as well. So definitely our clients, don't worry, we have everything scanned and saved in. But just having everything in one place for your heirs definitely are there to help you. It's there, having it for your heirs is going to help them. The reason I say it's important for them to know kind of where the documents are and those things is they may not know you've worked with Kopenbarger as your attorneys to set these things up. So they wouldn't necessarily know to call us if they can't find the documents that have our name on them. And you've seen that happen a lot of times. I unfortunately get calls, no longer, no longer now, but when I was at an older firm, we would get calls from clients just looking around like, oh, we had somebody, draft a trust for my parents back in 1979. We can't remember who it is. Does that happen to be your firm? And we'd look up the name like, no, sorry, unfortunately, it's not them. I don't want any of your beneficiaries or your successor trustees going to be in that place. So the Marriott Sacramento meeting is going to be on May 16th. So definitely keep an eye out in your emails. We'll be sending out information about that, but would love to see you there as well. Ooh, another question. If you don't want to name any of your beneficiaries as your trustee, who should you name? Great question. So your trustee essentially, it needs to be a capable person over the age of 18. That's essentially the only real rule behind it here in California. Generally, for my recommendations, if you don't want it to be a family member or if there's no, if there's a close friend, somebody, that could handle this type of role, friends are a good person. If you can't go through the list and find somebody on a personal basis, you would want to be your successor trustee. In that case, you can always choose a trust company, a private fiduciary. There's lots of different options available, and generally we will go ahead and walk you through those different options during your estate planning meeting. But I've worked with, tons of different private fiduciaries that do this kind of on a one-on-one basis, as well as large trust companies. And it has less of a personal feel to it, so it's not always right in every circumstance. But if you have beneficiaries who are going to fight over things, so especially in like blended family cases where everybody doesn't get along and there's not a lot of, it's not very copacetic, a private fiduciary or a trust company could be extremely beneficial in that situation for that as well. Okay, with that, we are going to conclude today's meeting. Thank you very much for attending, and I hope to see you all in the future.